streaming to YouTube.
We close the door.
Yes, and we're recording, so we're all set from the AV side. Thank you.
Good morning, everyone, and welcome. My name is John Rogers, and I'm an environmental manager with the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, March 20th, 2024, and it's time and place for the hearing examiner proceeding for docket number 2024-016, cause number 132-33. In the matter of the request for agency action, Oventive USA Incorporated for order pulling interest, including the compulsory pulling of the interest of certain non-consenting owners in the Chipeta, Utah 4-13, 4-3-14-23-26-35-1H well, producing from the drilling unit established for the production of oil and gas and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all the sections of 14, 23, 26, and 35, Township 4 South, Range 3 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah, and we will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division staff, legal counsel, petitioners, and the department technical staff for allowing these proceedings to go forward both remotely and in person. Before we begin, I'd like to know if there's any members of the public or respondent present that would like to make comments. Not seeing anything. Like the record show, there's no respondents are present. We'll take appearance of counsel at this time.
Thank you, Mr. Rogers. Mitch Mayo, Clear and Lair, PLC, on behalf of the petitioner of
Vision.
Gary White, Assistant Attorney General, on behalf of the Division of Oil, Gas, and Mining.
And my counsel is Emmy McKay of the Attorney General's office. Some procedural items first. I've received declarations from Mr. Ashley Ellison, the Senior Land Negotiator for Oventive, and Mr. Christopher Wall, as Senior Reservoir Engineer for Oventive, in this matter, and have reviewed them before this hearing. Does the division have any questions or objections to these declarations or individuals being sworn in as experts?
No objections.
Okay. Mr. Mayo, I believe these witnesses are present today.
They are present virtually.
And can we swear them in at this time?
Perfectly appropriate. Thank you.
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Yes.
Thank you. We'll accept them as experts in this proceeding. We'll now proceed to Mr. Mayo for his presentation.
Well, thank you, Mr. Rogers, hearing examiner, and staff here today. We appreciate you making this work in the busy schedule that the division has. You've covered a lot of the introduction that I plan to do. With me today are two witnesses, Mr. Ashley Ellison, Senior Land Negotiator, and Mr. Christopher Wall, Senior Reservoir Engineer with Oventive. They've both been sworn in and sounds recognized as experts in their respective fields. Mr. Ellison for General Petroleum Land Management, and Mr. Wall for Reservoir Engineering. Pursuant to the board's order on February 16th of this year, this cause was referred to the hearing examiner, Mr. Rogers, and this hearing here today, presuming that this matter remained uncontested. I'd like to let everyone know here today that is still the case. This matter is uncontested. In addition, this matter presents no novel or new issues with which the hearing examiner will have to grapple. As mentioned, pursuant to past practice of informal agreement, the testimony has largely been submitted via declarations today. Declaration Exhibit CC, the declaration of Ashley Ellison, and Exhibit BD, the declaration of Mr. Christopher Wall. The acceptance of that testimony in declaration form is based on their presence here in person to answer questions and verify the veracity. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code Annotated 40-6-6.5 and the implementing regulations, specifically 649-2-8A and -9A. A copy of the request at issue here today was sent by certified mail to the known parties sought to be compulsory pooled, and by regular mail to all other production interest owners within the zone. And their last address is disclosed by the relevant records and by Oventa's internal records. In addition, the request was mailed to all the relevant federal and tribal agencies, specifically the BIA and BLM, due to mineral ownership within the drilling unit. In addition, notice of the filing of this request and this hearing was duly published in the Uinta Basin Standard on February 28th, the Deseret News on March 4th, and the Salt Lake Tribune on March 3rd. I'd like to note that on March 11th, the division filed a response expressing no opposition to granting the request pending the presentation of evidence here today and confirmation of the declaration testimony. I'd also like to note that there are no other objections or responses to the RAA, thus the lack of contest. By way of brief summary, this cause involves compulsory pooling of the drilling unit established for Lower Green River Wasatch formations, comprised of sections 14, 23, 26, and 35 in Township 4 South, Range 3 West in Duchesne County. This drilling unit was established by board order entered just last May in cause number 130-19. And Ovintiv is the majority interest owner as shown in Exhibit F and is clarified in Mr. Ellison's declaration on file. Pursuant to the 130-19 order, which is on file as Exhibit B, Ovintiv spud the Chipeta UT 4-13, 4-3-14, -23, -26, -35-1H well, which I may call the Chipeta well or the subject well, on Ovintiv spud that well on August 13, 2023, with the first date of production of November 22nd of last year. At the time the request was filed in this cause, there were 22 existing vertical and directional wells producing or capable of producing from the subject lands. I may refer to those as the existing wells, as we did in the request. Those wells are all identified on pages 4 and 5 of the request for agency action. Pursuant to the 130-19 order, the existing wells converted to be payable on a drilling unit basis as of December 1st, 2023. There are and were at the time of filing this request no pooling orders applicable to any of the existing wells, so recoupment, waiver of recoupment is not an issue in this cause. There are a couple of corrections to be made in this cause, as is fairly standard in these pooling matters. Since the filing of the request, some parties have come forward, some information has been learned. With this one, however, there are no material corrections to be made because there have been no elections since filing. However, as addressed in paragraph 25 of Mr. Ellison's declaration, Ovintiv did have discussions about leasing with one of the named parties, Mr. Brian Sweeney. He reached out to Ovintiv upon receiving this and expressed the desire to lease. They have since sent him all the leasing documents and tried communicating with him several times to no avail. Because of that lack of communication, Mr. Sweeney will be pooled here today. Obviously, Ovintiv will continue to talk to Mr. Sweeney as he reaches out to communicate with them. With that clarification, there are still 13 parties named to be pooled and declared as non-consenting in the subject well. Those parties are identified on a list on page 2 of the request and are also discussed in paragraph 13 of Mr. Ellison's declaration. A copy of the request was mailed to each of the named parties with valid addresses as reflected on Exhibit BB, filed separately on March 18th. In addition, there are several estates to be pooled. Those are also identified on page 2 of the request. Although Ovintiv believes it has leased all such successors, voluntarily pools all the interest pursuant to the pooling clauses in those leases. There may be additional heirs or owners through those estates of which Ovintiv is unaware due to the lack of a sufficiently complete probate proceeding in Utah. Thus, out of an abundance of caution and pursuant to board's order on February 16th, 2024, Ovintiv named the estates to be pooled herein, and the requisite notice of opportunity to participate was provided to those parties by publication. Exhibit AA on file is a true and correct copy of the affidavit of publication, and I'd like to pause for a second to acknowledge if anyone tried to look at those affidavits of publication, they were almost completely unintelligible. There was some sort of a formatting issue with the papers we're trying to get sorted out. If the division or hearing examiner would prefer a more legible copy, we'll do what we can to get after the hearing. As reflected on Exhibit W, as discussed in paragraph 23 of Mr. Ellison's declaration, the average weighted fee landowner's royalty of the subject well to be applied here today is 18.8251734.8%. Finally, notice of the REA and the hearing today was provided to all production interest owners in the subject unit as outlined in Mr. Ellison's declaration and as displayed on the certificate of service on file. Costs, including plug-in costs, are just and reasonable, and the risks incurred in the subject well justify the imposition of a 300% risk compensation. As the record reflects, none of the parties have appeared or opposed, and there is no one here today to contest the matter. With that, I'm ready to begin with Mr. Ellison, and we'll do a quick run through if that's all right. Can you hear me okay still?
I can, yes.
Perfect. Mr. Ellison, will you state your name and business address for the record?
Sure. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77382. And the business is Ovintiv USA, Inc.
Perfect. And your position with Ovintiv?
I'm a senior land negotiator with Uinta Basin.
Okay. And do you have responsibilities over the drilling unit issues at Chiquita Drilling Unit?
Yes, sir.
Okay. Thank you for that. I've discussed, and the hearing examiner mentioned, your declaration testimony filed as Exhibit CC. Are you familiar with that declaration?
Yes, sir.
And have you reviewed and become familiar with all the allegations in that declaration?
I have, yes.
Does that declaration constitute your full and accurate testimony here in this cause?
Yes, sir, it does.
Okay. And are there any clarifications or anything you would like to add to that declaration here on the record?
No, sir.
Okay. Having been recognized as an expert in general land management issues, can you say whether, in your expert opinion, the terms and conditions of the JOA, which were submitted as Exhibit U in this cause, are fair and reasonable and consistent?
Yes, they are fair and reasonable and consistent.
I appreciate that. Without anything further, I think it's appropriate to turn Mr. Ellison over to the division or hearing examiner for follow-up questions as necessary.
Division?
Mr. Ellison, my name's Gary White. I represent the division. I did have a few questions for you. Your counsel talked about Mr. Brian Sweeney. I believe that's his name.
Sure.
How many times did you have contact with him?
We have a land group, Lone Wolf Energy, that kind of spearheads that effort. They've contacted him a number of times and finally did get a hold of him. And then he went kind of unresponsive after that time frame. This happens occasionally where we do finally get a hold of people, and then for one reason or another, they do not follow up to lease. We would love for that to happen, but it does occasionally happen where we just can't get a hold of them anymore after the initial contact.
Thank you. And this next question, it may be one your counsel can answer as well, but say that there's an order for spooling Mr. Sweeney, but he is still interested in leasing. What happens then?
I think if you're asking my perspective, I think the board's orders are binding on all parties who receive due process, legally have the opportunity until they come in and change those. And the board retains continuing jurisdiction. So Mr. Sweeney, if in a month said, wait, I do want to lease and I'd like to, he's always welcome to petition the board. That being said, as Mr. Ellison indicated, it's Ovintiv's position, as I've understood it, to want to lease anyone they can for their units. And I guess maybe it's appropriate for you to kind of flesh out, Mr. Ellison, any Ovintiv specific application.
Yeah, I would say these forced poolings are always a last resort. We work very diligently to to lease any unleased owner in our units. And if we cannot get a hold of somebody by the time we force pool or do these proceedings, that's kind of locks them in, I suppose, at that point. It's unfortunate. And I would very much like to have worked out an agreement with that individual.
That's helpful. Thank you.
Yes, sir.
My clients may have questions. Anything? Okay, that's all for me. Thank you.
Thank you. I got a few questions here. You talk about conversion, and I read through this many times. It confused me.
Okay, that's probably my fault.
No, could you explain how there's existing wells in this building, how that conversion works?
Is that a question for me?
Well, you explained it, whoever's best on your.
Well, I don't know. I'm happy to answer, Ash. My understanding of conversion is essentially there's a concern with units that have been developed prolifically by vertical wells, that when you transition to a horizontal well scheme, those vertical wells are still producing, essentially have a difficult time locating any horizontal wells that don't impact those existing vertical wells. And so Vinton, a while ago, and I believe before then, kind of made the conscious choice, it seems, to say essentially, if we're going to develop this as a horizontal unit, we may not want to shut in these existing vertical wells, but the only fair thing to do is to convert allocation of those existing wells to a 1280 basis. And that way, no matter where we put a 1280 well, even if it's in theory right next to one of these verticals, no one's being hurt because they're all receiving the same allocation, regardless of which straw it comes out of. I think that's the idea behind it. And I know there was a lot of pushback when this kind of plan was first going through the board, and a lot of operators came in and voiced opinions. And so I think this conversion and the timing on conversion was actually part of not necessarily a settled determination, but kind of input from a lot of outside parties about how best to convert these units. Because there's two ways to deal with it. There's internal setbacks to keep you away from really heavily developed vertical well area when you're doing horizontals. But if it's heavily developed, like this unit, for example, you end up with fewer horizontal targets than maybe you like. And so the way around that is either to shut in existing vertical protection, which doesn't really benefit anyone, or to convert them to a drilling unit basis so that the location of the horizontal well is no longer a concern.
So these individuals that are being forced pool will share in that conversion.
These parties that are being pulled into this well, but is only payable on a 2,000 acre basis, right? This is the Chipeta well is under the 130-19 order is payable on that unit wide basis from the date of first production. So they, yes, will be in that's the well they're being pulled into. All the other wells are tribal. And so these owners didn't have an interest in any of those existing wells, but the tribe will share in by converting all of them.
So they won't share in the whole unit, including the tribal wells, aren't they in the unit?
All of the wells, they all will start paying on this same allocation. So yes, I guess if that was your question, they will start receiving a fraction of pay from those existing wells. If that's the question.
I know
Is
it's
that
small.
correct, Ash? Did I say
Yeah.
that?
Yeah, I would agree with that.
Okay.
And I have another question here. I was reviewing the 130-19 order. Well, first of all, I read this and I was surprised. I guess I should have known this, but we now have nearly 3-mile laterals.
Several of them. Yeah.
Well, and so I look back on here and I'm looking at the order 130-19. I should have highlighted it. Sorry to be patient.
You're the hearing examiner. You should do whatever time you want.
Okay. I'll have to do it from memory, but it says, the order says that they will allow up to a 1.5 mile lateral. I mean, not, 2.5.
Okay.
I did the math here, and this is nearly 15,368 lateral length. That's nearly 2.9 miles.
Mr. Ellison, any
Mhm.
thoughts on what Mr. Rogers just said to us? Do you
Uh,
understand?
Yeah, I don't. Another layman did that particular hearing. And I know it was always the intention to drill the 3 miles to fully develop that area as it abuts.
Ash, is this a situation where there was an issue with section 35 wasn't leased and there was a concern about not penetrating 35 until it was leased?
Yeah.
Maybe a part of that.
So I think section 35 is a tribal, is fully tribal, and it's my understanding that the tribe and potentially the board wanted that lease included in this DSU, so it was not stranded. And we also felt the need and the want to include it for those very reasons. And in the interim, we initially did not have a lease with the tribe for those lands. And we have worked out a lease. It is kind of still in the works, I suppose. So I think potentially the crux of that issue is that it was included sort of after the fact into the unit. The initial well did not penetrate that lease because it's smaller, basically, as the dome of the southern unit kind of interacts. But
This well was drilled on the eastern boundary of the drilling unit. And the section 35 tribal portion is more on the western side. So if this had been a western side unit, it would have probably penetrated 35.
yes, 100%. And for future development, for future wells that are further west, we will, I'm sure, penetrate section 35. So the nuance of the tribal lease, I think, is somewhat the answer to that question, I believe, sir.
Well, as I look on this, the section 35 is an odd little shape thing at the bottom, and this well did not penetrate that. But it did penetrate 14, 23, and 26, nearly the whole length, giving it nearly 15,000 plus length of producing zone. And the order says 2.5.
And I'm actually trying to.
I found it. You want me to read it to you?
Well, if you can just tell me where it is and I'll look at it.
It's on page 6 of the order.
Paragraph 8.
Yeah, would you read? I mean, you might as well read it for the record.
Preventive plan to extend the LL8Z well development and subject formations to the subject lands, including the drilling of up to a 2.5 mile long lateral, as evidenced by Exhibit F, amended to evidence by, and Mr. Lear's testimony with respect to that. Okay. And I know it's not part of the force pulling matter here, but it's something I read through and I thought, okay, this needs to be fixed.
Well, and here's, I guess, now that I've looked at it and read that, I think, again, to Mr. Ellison's point, unfortunately for the hearing examiner division, neither of us were involved in the 130-19 order. So we're both trying to figure it out on the fly. It's fairly, I guess, easy in some ways to reconcile it because that's a finding of fact. What it says is Ovintiv's plans at the time, and these were the first two more than 2 mile laterals state, as I understand, at least in this iteration of basin. And so Ovintiv's plans, it sounds like in the findings of fact, were to drill up to a 2.5 mile lateral. But the order is clear that it says, up to 40 LHZ wells may be drilled and produce on the drilling unit, and that they just have to have heel toe setbacks and side setbacks accordingly. But nothing in the order that I can see limits the length of the well to 2.5. And the order really is the instructive part where the board says, this is what we authorize you to do, which is, I'm assuming, why the division approved the permit. Because the order makes it clear that it's legally permissible to do this. Ovintiv's plans, as presented in May, were to drill a 2.5 mile, but it turns out they were able to get it a little farther.
So this is not the restrictive case. The restriction is based on heel toe setback.
Well, I think that's right. I think what I would say is what's authorized is what the board orders. The factual findings, the conclusions of law are, based on evidence submitted and determinations of relevant legal authority as to justify the order the board is entering. And so the order is really what I think of as the instructive portion of the final resolution of these hearings. And I don't see, at least in my quick surveillance of it, I don't see any limitation on the length, just that it has to be greater than 2 months. And there is confusion there. In a perfect world, it would say we're planning on drilling these. But I think if you look at that paragraph in isolation, it's confusing. If you look at the rest of the factual findings, it's clear they're looking to set this up as a extra long lateral horizontal development area based on some unique geological issues with the greater Monument View, also with the kind of desire that a lot of operators are expressing to begin testing longer laterals to see if they can improve the economics of some wells.
And if I may add, Mitch, yeah, I would say somewhat the point is so we don't drill shorter wells in a jumbo unit, so to speak, to ensure that we prevent waste and develop the entire spectrum of that DSU.
If you drill a few feet past a 2 mile, you're paying on a 3 mile basis, but you're barely draining that third section at all.
Yes.
And so the idea was at least 2.5 miles.
Yes.
To ensure you're getting far enough into that third section to justify including it.
With, I would say, to fully develop and drill as far south in this unit as possible to make sure we develop it as much as possible and prevent waste.
So what we're saying here, and I guess it's from my education also, is these are extra long units, kind of long skinny ones, or normally you're looking at 1280s. But your limitation on the length of a well is based strictly on heel toe setback.
I mean, the board.
And the length of the drilling unit.
That's right. And I think in this one, the board said essentially, yes, we approve this drilling unit, 1280s, we have no problem with. There's a couple little funky sections at the bottom of this 1280 that if we set this as a normal 1280, those would probably not get developed. And so to fairness, we'll include those in this and give you a chance to try and reach them. But to be fair to the 1280 owners, you have to drill it at least 2.5 miles so that it justifies combining production.
I think it's coming clear now. So essentially, if you were to leave out section 26, back in the spacing order, section 26 and 35, no one would drill it, because 35 is so odd.
They might be drilled by vertical wells,
Yeah,
but
not.
not, the way the basin's going, not as aggressively as.
And I know this boundary's always been an issue.
Yeah.
All right. Okay, let's see. Yeah, that's all the questions I think I have. The division, do you have any communication at this time?
Well, I think they still have one more witness.
Oh, I've got one more witness quick, Mr. Wall.
Hey, sorry, I didn't mean to ignore you, Mr. Wall.
Okay. Mr. Ellison, just hang tight and mute yourself, but pay attention because we may have follow-up for you.
Sounds good.
Now I'll move on to Mr. Wall. Will you state your name and business address for the record?
Yes, name is Christopher Wall. Business address is 4 Waterway Square Place, 100, The Woodlands, Texas, 77380.
Okay. And your position generally with Ovintiv and with respect to the drilling unit here?
Yes, I'm a senior reservoir engineer and I work the Utah assets for Ovintiv.
Okay. And I'm assuming that gives you some responsibility over this unit.
Yes.
As has been mentioned, your testimony was submitted via sworn declaration. was been filed as Exhibit DD in this cause. Are you familiar with that declaration?
Yes,
And have you reviewed all the allegations contained there?
yes,
Did you execute the declaration or authorize your counsel to sign it on your behalf?
yes,
And finally, does that declaration represent your full and correct testimony here in this cause?
yes.
Are there any modifications or clarifications you'd like to make on the record while you have the chance?
No.
Finally, quickly, you've been recognized as an expert in this cause again. Would you, give your expert opinion on whether the actual costs of the Chipeta well, as reflected in Exhibit I, were fair, reasonable, and necessarily incurred?
Yes,
And I'm assuming that the Chipeta well was economic, as at the time it was drilled, as contemplated under the 13019 order.
yes, it is an economic well.
And finally, the risks discussed in paragraph 9 of your declaration. Is it your expert opinion that those risks justify imposition of a 300% discompensation award?
Yes, it does.
With that, I'd open Mr. Wall and Mr. Ellison to questions from the Division of Hearing Examiner.
Mr. Wall, the AFE had the anticipated costs, I think over 2 million higher than the actual costs. Can you help us understand why the projected costs were so much higher than the actual costs?
Yes. So the estimated, most of the cost under, we came under cost mostly on the completion side. And a lot of that had to do with one, a small design change that we wanted to execute on this particular well. Also, it turned out our sand cost had come down significantly. So that led to, about $2 million worth of savings.
Just in the sand?
Not just in the sand, but there's also, chemicals and pumping costs, et cetera, that go into that as well. I just think the largest portion was on the sand itself.
Okay.
It wasn't 2 million in sand alone, 2 million spread across everything that goes into completing a well.
You early in your answer, you mentioned that I didn't understand it. You were able to change something, or what was it to do with the design?
Yeah, so yeah, I can explain a little bit more about that. So when we set up our well bores to do various different things after we're done drilling them. So our typical design case that we run with is what we call, a 240-foot completion stage. And in that, we're going to pump about 2,000 pounds and 2,000 gallons of fluid across that stage. So in this particular well, we decided that we wanted to cut back on our water and increase the sand a little bit. So basically that allows us to shorten our pump time because we're not pumping as much fluid, but we're still able to put away as much sand as we want in that across that 240-foot stage. When we do, we contemplate these changes, we're looking at data that suggests that this is not going to be something that would harm the production of the well, but it could possibly incur cost savings. And in this case, it did do that, where we were able to, reduce our pump time, which reduces our costs. And then also, the sand market was in our favor, where we were able to find some savings on the sand side. So I hope that kind of helps explain that.
It's helpful to me. Last question from me. Your declaration at paragraph 9 outlines some potential risks. If I understand this, though, none of the risks that were potential risks actually took place. Am I reading that right at paragraph 9?
Yeah, that is correct. Yes. So
All
the
right.
risks still exist, right? They don't go away. We were just able to operationally overcome them, or we're not, colloquially bit by the risks. They did not.
Got it.
Yeah.
My clients may have some follow-up.
No, I think you covered it.
Okay, that's it. Thank you so much.
Thank you, Division. I do have a few questions on the side of risk here. You mentioned that there's a clay content and you're drilling the Uteland Butte. Is it because the Uteland Butte is thinning and being filled with clay, or the inner stringers within the Uteland Butte itself? I guess I'm trying to understand the clay content and how that's affecting your drilling.
Yeah, so when you have clay, the Uteland Butte itself, I think it's fairly consistent across the acreage that we have. And in this particular zone, I wouldn't say that the clay content itself is changing. But when you're drilling through high clay content intervals, it's hard to control with your mud properties. So the clays will actually swell, and that changes, the size of the hole that you're drilling. And it causes you to, it has high potential to stick the pipe. So in other words, you get stuck as the clay swell and your hole size shrinks. It collapses on your drill pipe, and you're no longer able to, rotate, drill, go farther in or come back out. So it's not really about the changing, it's just the existence of the clay itself. That makes sense.
Okay, and I'm a geologist, so I got to envision this as rock. Okay, so are we looking at stringers of clay within the Uteland Butte, or is this the clay content within the rock body itself is increasing, or is that which clay are we looking at?
So we're looking at the clay content within the rock itself.
Okay.
There are some interbedded, sand and shale bodies, but we're talking about really, really, really thin sand bodies. So, as we're drilling horizontally, these are not, packages that are completely consistent. So you're going to be running in through, maybe 100% clay and then 100% sand and then 100% clay. Could be something like that, but more often it's just, probably 75, 25 kind of on average. And, sorry, I'm not a geologist. This is just my understanding, speaking with geologists.
I'm just trying to envision this as I'd see an outcrop, and so anyway, that's interesting to know. And then we talk about this 15,000-foot lateral. Explain the risk going from a 2 mile to a 3 mile long well.
Yeah, so, we're very confident that we can drill 2 miles. We can do that repeatedly, but then as you increase the length on this, it's another 5,000 feet of pipe that we're trying to push through this hole. And we've never been there before. We don't know how the formation is going to react to being open for longer as we drill through it, because it's going to take us extra days to drill. Also, we don't know, if we have the right equipment in terms of pump pressure that we can run to adequately clean this hole out past the 2 miles that we've been doing. So there's some additional operational risks just because we haven't done it before. And a lot of these things we can overcome as we get better at it. But, drilling extra footage comes with extra operational risk.
It sounds like you have been successful at it.
At least twice.
Okay. All right. So obviously others are watching. Do you see this as being a trend in the basin?
Yeah, I do think that other operators will start to copy what we're doing. And that's a good thing for the basin.
Those are all the questions I had concerning risk. Any more witnesses? You have 2, correct?
That's it for witnesses. So I'll give you my conclusion, or I can wait if the division has anything laid out.
We'll wait till after the division. Division, do you have anything you'd like to share?
No, based on the evidence presented and the exhibits and declarations, we don't have any objection to the granting of this request.
Okay, so it's my understanding the division has no objection to this action. And so we'd like to go to closing. Well, let me take a few minutes here. Can we have deliberate by council?
Yeah, of course. 5-minute recess. Are we? recess for.
Yeah.
You guys just hang tight. We'll be back in 4 minutes.
Thank goodness.
Yeah.
I think we,
I think so.
great. Go back on the record. Hey, back on the record. Mr. Mayor, would you like to move for admission of your exhibits this time?
That would be great. I'd like to move for admission of exhibits A through DD.
DB,
DD,
DD.
A through Z, and then AA, PP, CC.
You get that?
Yes.
Okay, so admitted. Okay, closing now. You have any closing arguments you'd like to present?
Just briefly, yeah, I'd like to remind everyone here that full notice was provided to everyone entitled. There were no objections or protests, and even the one party who did have concerns still has yet to follow through on memorializing those concerns in this hearing. I'd like to remind everyone the statutory and regulatory requirements have been met, and the requested relief is fair and reasonable and in keeping with the vast majority of the board's orders entered. I'd also like to remind the board that in some ways, the drilling of 3 Mile wells is akin to the going from sectional wells to 1280s, something that the board may have thought sectional wells at the time and kind of become a science. They understood that drilling 1280s brought a whole new set of complications. And I think the same applies with drilling 3 Mile wells. There's going to be a new set of challenges, and no matter how much they've learned from 1280s, there's additional risk drilling that 3rd mile. With that included, I would just like to thank the hearing examiner and division staff for making this happen today, and I would submit.
Division, any more comments?
No, just appreciate all the preparation and the good questions. Thank you.
Okay, having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find omitted to provide a sufficient notice of opportunity to non-consenting owners, and that owners identified in the request for agency action did not timely elect to participate in the wells, and therefore should be deemed non-consenting. I find it 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose and request the non-consent penalty. I find that omitted to met its burden of proof to show that they are entitled to forfeiting of this named interest and other relief requested in the RAA. Mr. Mayo, would you please prepare the order? I will present the findings and conclusions to the board when they meet next week.
And I'll be happy to. Hopefully I can get the draft out tomorrow for review.
Any other comments before we close? No other comments or issues? I thank you for your participation, and we will adjourn this proceeding.
Thank you. Ash, you can sign off. Chris, unfortunately, you're stuck with us.
Thank you all. See you next month.
Since we just had a break, is everyone okay?
Yeah.
Good to go.
Start with,
If Peter Burns is still unavailable, Peter, are you there?
Just lost Peter. For some reason.
Yeah, I think Peter had some difficulty hearing the audio from the hearing, so he's going to try and log back into the meeting. See if that resolves the issue.
Thank you.
okay.
Do we want to wait for Peter to
Oh.
log back in?
He's the first witness, so it probably makes sense, but
Okay.
I imagine he's
Okay,
gonna
I'm
be quick.
sorry.
That's okay. We're just gonna wait on Peter for a minute.
I think production does take a few minutes, but I think
Yeah.
he's gonna text and say, I can't hear anything on the sound. If he knows that he's out of the meeting.
Probably an indication he does.
Yeah, there's an extra seat next to Christopher right there.
That's true.
Tracking down the hair.
On the bathroom.
Hey, Carmen, if you want to go ahead and put us on break, we can do that. I believe we are good to go. Carmen, if you did put us on break, you can bring us back. Okay. Mr. Rogers, we're ready to proceed.
Okay. We got everyone. Okay. Good morning, everyone, and welcome. My name is John Rogers. I am an environmental manager with the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in these proceedings. Today is Wednesday, March 20th, 2024. And this is a time and place for the hearing examiner's proceeding for docket number 2024-017, cause number 132-34. In the matter of the request for agency action, Oventive USA Incorporated for order pooling interest, including the compulsory pooling of the interest of certain non-consenting orders in the Array, Utah, 4-13, 4-3-13-36-7HX well, producing from the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all of sections 13, 24, 25, and 36. Township 4 South, Range 3 West, with a special meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I would like to thank the division staff, legal counsel, petitioners, and department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Seeing none, let the record show that no public respondents are present. We'll take appearance of counsel at this time.
Thank you, Mr. Rogers. Mitch Mayo of Lear and Lair PLLC on behalf of the petitioner, Oventive USA Inc.
Gary White, Assistant Attorney General on behalf of the Division of Oil, Gas, and Mining.
My counsel is Emily McKay of the Attorney General's office. Some procedural items before we begin. I received declarations from Mr. Peter Burns, a senior land negotiator for Oventive, and Mr. Christopher Wall, a senior reservoir engineer for Oventive for this matter, and have been reviewed before this hearing. Does the division have any objections to these declarations or these individuals being qualified as expert witnesses?
No objection.
They are recognized as experts in their particular fields for this matter. Mr. Mayo, I believe the witnesses are present today.
They are.
And can we swear those in at this time?
That would be perfect.
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes.
Thank you. We'll now proceed to Mr. Mayo for your presentation.
Thank you. The witnesses just sworn in. We have, despite the labeling on the screen, we have Mr. Peter Burns. If you'd raise your hand. He's a senior land negotiator with Oventive. And again, in this matter, Mr. Christopher Wall, raise your hand if you would for the YouTube audience. Thank you. Senior reservoir engineer with Oventive as well. Pursuant to the board's order on February 16th in this cause was referred to the hearing examiner and this process here today upon confirmation of the matter remained uncontested. That is still the case here today. In addition, there are no novel or unique issues to be decided. Additionally, as the hearing examiner mentioned, the witness testimony was provided via sworn declaration earlier. Exhibits T and U were submitted on March 14th. And those are allowed to stand for their testimony, subject to them appearing today and making themselves available to confirm the declarations and to answer any questions that may exist. I'd like to thank the hearing examiner and the division for recognizing Mr. Burns and Mr. Wall as experts in their fields. Mr. Burns for general land management and Mr. Wall for reservoir engineering and development. The board and by hearing examiner, or by designation, the hearing examiner, have jurisdiction over this matter pursuant to Utah Code annotated 40-6-6.5 and the implementing regulations, including 649-2-8A and -9A. A copy of the request was sent by certified mail to the known parties sought to be pooled and sent by regular mail to all other production interest owners within the drilling unit at their last known addresses of record as disclosed by the relevant records or Oventive's internal records. In addition, a copy was mailed to all the relevant federal and tribal agencies, specifically EIA, BLM, due to mineral ownership within the drilling unit. On March 11th of this year, the division filed a response in this cause and noted that it had no opposition to granting the request pending the presentation of evidence here today and the receipt of the declaration testimony. I'd like to remind everyone there were no other objections or responses to the RA timely filed. Again, by brief summary, this cause involves compulsory pooling of the drilling unit established for Lower Green River Wasatch Formation production, comprised of sections 13, 14, 25, and 36, Township 4 South, 3 West, Duchesne County. This drilling unit was established by the board in December of 2022 in cause 130-14, and Ovintiv is the majority interest owner as shown in Exhibit F. I'd like to alert everyone in case they didn't notice yesterday, we filed a corrected Exhibit F or a supplemental Exhibit F. I have to check the exact naming on it. We filed it yesterday and brought copies today for board secretary, essentially clarifying the corrections that we're going to address later as to who is pooled and who is not pooled. Again, this well was authorized pursuant to Order 130-14, a copy of which is on file as Exhibit B. Pursuant to that order, Ovintiv spud the URE UT 4-13-4-3-13-36-7HX well, what I may call the URE or subject well. It was spud on October 1st, 2023, with a date of first production of November 2023. At the time the request was filed, there were 15 vertical or directional wells producing or capable of producing from the subject lands, which I may refer to as the existing wells. Those are all identified on pages 4 and 5 of the request for agency action. Pursuant to the 130-14 order, the existing wells converted to a drilling unit basis as of December 1st, 2023. And I'd like to note there are no pooling orders applicable for any of the existing wells, so there's no need to waive recoupment in this cause. A couple corrections. First, as I mentioned, the corrected exhibit or supplemental Exhibit F was filed yesterday to clarify that the rest of the corrections coming. Second, I'd like to note there was a corrected Exhibit N, the acreage-weighted royalty, that was filed fairly shortly after filing the original exhibits. It was filed on February 26th, and this was to clarify a transposition, essentially that all the acres under a certain lease weren't included. One of the 8 people was considered not to have been a part of it. After conversations with outside parties and another review of title, it was clear that that acreage should be included. So simply to say, lease number 79 on the acreage royalty, its acreage was updated via the corrected Exhibit N on file. The other correction to address, again, as is standard in these pooling matters, is the change in parties from what were named in the request to what is being pooled here today. In the request for agency action on file, there were 4 named parties to be pooled: Croft Oil Company, Inc., and then 3 presumed heirs: Katie Kisling, David Pitt, and Farrah Lynn Pitt, all of whom are presumed heirs of Terry Russell Pitt, some of whom are also presumed heirs of Carrie Pitt. However, each of these parties have been removed and are here being removed from being pooled, as explained in Mr. Burns' declaration in paragraph 25. Because of this change, there are no longer any named parties to be compulsory pooled and declared as non-containing parties in the subject well. Ovintiv has submitted a supplemental Exhibit F reflecting this fact, and Mr. Burns will be happy to address any questions about that during his testimony. Despite the fact that there are no named parties to be pooled here today, there are still several estates to be pooled, again, as identified on page 2 of the request on file. Although Ovintiv believes it has leased and located all such successors and voluntarily pooled their interests pursuant to their pooling clauses, there may be additional parties claiming buy-through of these estates that are yet unknown. For that reason, and out of an abundance of caution, Ovintiv is including those estates to be pooled here today. Pursuant to board order entered on February 16th, the notice of opportunity to participate that's required to be mailed to them was provided to them by publication. And Exhibit R in this cause is a true and correct copy of the affidavit of that publication. I'd like to remind everyone, no responses were received to that. As reflected on the corrected Exhibit N, the average weighted fee landowner's royalty in the subject well to be imposed here today is 19.533393.62%. With that, I'll probably dive right into my testimony or my examination of Mr. Burns. Mr. Burns, are you ready?
Yes, sir.
Okay. Can you please state your name and business address for the record?
Yes, Peter Burns, Oventive's business address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
Okay. And can you please remind the hearing examiner and the folks here today, your position with Oventive and as it relates to this unit?
Yes, I'm a senior land negotiator at Oventive with responsibility over this drilling unit, among others, within the Uinta Basin.
Mr. Burns, I'm going to ask you a couple quick questions about your declaration testimony. Are you familiar with Exhibit T? Have you reviewed the exhibit that's been filed as Exhibit T, the declaration of Peter Burns?
Yes,
Are you familiar with all the allegations contained in that declaration?
yes,
And did you sign that declaration or authorize your counsel to sign it on your behalf?
yes,
Okay. Did that declaration, as testified here today, does that constitute your full and accurate testimony in this cause?
yes.
Is there anything else you'd like to clarify or add about that testimony on the record?
I think just a small clarification is that we do reference the word allotted interest within the declaration. However, there's no allotted interest within this DSU. It's strictly tribal for the vast majority, and then a 40-acre fee tract. So allotted interest was included just as an oversight. So just as clarification, there is no allotted interest within this unit.
Thank you for that clarification. Finally, I mentioned briefly the supplemental exhibit F that was filed yesterday. We probably need to have it authenticated by you as well, because it wasn't mentioned in your declaration, having been filed after your declaration. Do you recognize supplemental exhibit F that was filed?
Yes,
And was it prepared by you or under your direction or supervision?
yes.
And can you just quickly, summarize what that shows and why the supplement was necessary?
Yeah, so when we filed the request for agency action, there were people we thought needed to be pooled. However, we were able to secure a lease from the successors to Croft Oil Company. And then also after further review, some curative documents, as well as discussion with the Pitt family, we determined that they no longer need to be pooled. We're covered by prior leases and further understanding of the title and heirship of that family. So because of all of that, we're only seeking to pool the unprobated estates within this unit. So that's why supplemental exhibit F shows 0% for the compulsory pooled interest. And just as that asterisk indicates, we believe we've acquired all leases on all unleased interest, and therefore only seeking to pool the unknown heirs and unprobated estates that exist.
Thank you for that. You've been recognized as an expert in general petroleum land management here in this cause. Can you provide us with your expert opinion as to the terms of the JOA to be imposed? The JOA submitted as Exhibit L.
Yes, I believe that's a fair and reasonable JOA, and it's one that we commonly execute when we're in a non-operated position, and has become a fairly standard joint operating agreement across our acreage position within the Uinta Basin.
Okay, I appreciate that. With that, I have nothing further for Mr. Burns, and I'm happy to open him up to division or hearing examiner questions.
Mike?
Yeah, Mr. Burns, going to paragraph 25 of your declaration, I just had a couple follow-up questions about the Pitt family. Toward the end of paragraph 25, it says, Oventive is determined that these 3 individuals either do not own a record interest or have leased their interest to Oventive. Can you provide some more detail there?
Yes, so there was some confusion as to whether the Pitts owned Terry Pitt and Tara Lynn Pitt owned as joint tenants versus tenants in common. And so we secured leases from quite a number of the heirs prior to understanding that they did in fact own as joint tenants. So When Terry Russell Pitt passed away, all of his interest was fully vested in Terrell Lynn Pitt, who we had leased. And so that's why, we don't need to pool any of their interest, as she became fully vested with the interest, and she had previously leased to us.
Okay, thank you. Going to paragraph 7 of your declaration, Mr. Burns, you stated the third line there, Oventive spud the subject well on October 1st, 2023. I've heard terms of our dry spud and wet spud. Can you provide some clarification on what actually took place on October 1st?
I would have to review the completion report, which I don't have in front of me, but it's common practice for us to use a spudder rig, like a smaller rig, to drill the surface casing prior to the big rig coming in. So I'd have to confirm this spud date to determine which rig that was with.
To follow up maybe with his question, the intent was to use the dry spud, if that's what he's referring to, not the wet spud. The first turn of the bit at the surface, that's your intent in using for the spud, is that right?
Yes.
Okay.
What I understand.
Thank you, Mr. Burns.
Thank you.
Okay, I've got a couple questions, just to kind of clear things up. Mr. Mel, you in many of these cases put people in, or heirs into two parties, a non-consenting party and a deceased party. The non-consenting, is it safe to say those are people that just said, no, we don't want anything to do with you? They weren't located at all, unlocatable, or they just weren't responsive? Are they all fit in one category?
Well, yes and no. I think the reason they have different names in the pleading is because then we use those to short side for different things, right? The deceased parties, they don't get an acre-created royalty because they're deceased, but they still own a record interest, kind of. So the distinction between deceased parties and non-consenting parties is so that when we say later, all the non-consenting parties receive an acre-created royalty, there's clarity as to which parties do and don't.
So these deceased parties, they didn't go through probate. So they obviously somewhere have some sort of rights that has not been declared legally.
That's
So you put them there, or eventually if they did probate, they would have the ability to come in as being non-consenting or being in part of it, with the penalty, of course.
That's right. With an acre-created royalty assigned to them. So, someone can come forward 7 years from now, 10 years after the well was drilled and say, I'm an heir. So it would be obligated to pay them an acre-created royalty from first production.
So does that money, royalties, go into a fund that then eventually probably turned over to the state as unclaimed property, or it is accounted for?
It is. In this one, I would say it's, I guess this is where all of these hearings get confusing, is because someone can see both, Terry Russell Pitt and Terrell Lynn Pitt are a perfect example, right? I think the idea is when a title opinion is done, a company knows exactly who owns. And that's not true. Unfortunately, attorneys are helpful, but not that helpful. And so most of the time, we give an answer that's something like 95% of the people who own are these people. The other 5%, we're not really sure about. We think it's these people. We think it might be this person. There's all these documents from the past that are confusing or create problems. And until a court says one way or the other, I can't say. And so Terry Pitt and Terrell Lynn Pitt are a perfect example. There was a deed that had a handwritten notation that said as joint tenants. And it went to Terry Russell Pitt and Terrell Lynn Pitt, father and daughter, as I understand it. But the handwritten notation wasn't initialed by anyone. So there was a question as to whether it actually created a joint tenancy or whether it created a tenancy in common where each of them received 50% of the interest separately. that problem is compounded when Harry Russell Pitt passes away and there is no probate of his estate because Ovintiv can in good faith, their title attorneys in good faith can say it is entirely owned by Terry Lynn Pitt and it is all leased. They also can say there is a chance one of Terry Russell's Pitt's other kids is entitled to that interest and it is unleased.
But that burden is upon that person.
That's right. And so Ovintiv, all the operators that come in for poolings have to make that decision with their counsel how to treat this person. And so I guess the short answer is there's not a clear, bright line, as much as we all know. If it helps.
Okay, next witness.
Next witness, Mr. Wall, if you're still around.
I'm still here.
Okay, Peter, please stick around and pay attention. There may be follow-up questions for you in a minute. Mr. Wall, I'd like to remind you you're under oath in this matter as well. Could you please state your name and business address for the record?
Its name is Christopher Wall, business address 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
Okay, and your position with Ovintiv and with respect to the drilling unit here at issue.
I am a senior reservoir engineer with responsibility over this unit and others in the Uinta Basin.
Perfect. And are you familiar with what's been submitted as Exhibit U in this cause, the declaration of Christopher Wall?
Yes,
Have you reviewed that declaration?
yes,
And are you familiar with all the allegations contained therein?
I am.
Did you execute the declaration or authorize counsel to sign it on your behalf?
Yes,
And does the declaration constitute your full and accurate testimony here in this cause?
yes,
Any clarifications or modifications you'd like to make on the record?
no,
Finally, expert opinion questions. You've been recognized as an expert in reservoir engineering and development here today again. The actual cost for the Ouray well at issue, as reflected in Exhibit P, is it your expert opinion those were fair, reasonable, and necessarily incurred?
yes,
And would you say the Ouray well was quote unquote economic to drill as contemplated in the 130-14 order?
yes,
And finally, do you believe the risks discussed in paragraph 9 of your declaration, including that this is one of the first two 15,000 foot laterals in the basin, justify the imposition of a 300% risk compensation award?
yes.
Okay. With that, I'm done with Mr. Wall and open him up to question.
Ms. White?
Thank you. Mr. Wall, I'm going to ask you the same question as it relates to this well. The costs, it looks like the actual costs were about 1.7 million below the AFE amounts. Can you help me understand why?
Yeah, so this again was mostly due to a change in the completion design and able to capture some savings from the sand market.
So it's basically the same savings that you described in the last matter.
Yeah, that's correct. The savings isn't quite as much because we had some overruns, or primarily on the drilling side in this particular well, slight overruns, but.
Thank you. And going to paragraph 9 of your declaration, you outlined some of the, I don't know that it's all the same risks, but you outlined some of them. But it doesn't appear that you encountered the drilling risks with regard to the Ouray well. Is that fair?
Yes, that is fair. The risks still exist, pre-drilling. I'd also like to point out, this particular well was drilled up dip, which meant that, not only were we going 3 miles out, but we were also going up about 900 feet. So it's an additional complication that we don't often run into.
Okay, Mr. Wall, thank you. That's all the questions I have.
Okay, Chanel, does this conclude your presentation or?
It does subject to closing. If you indulge.
Take time with the division, your presentation.
Based on the testimony that's been received and the explanations from these witnesses, the division has no objection to granting the request for agency action.
Okay, my understanding, the division has no objection and the agency action, that's correct?
Correct.
We'll take closing statements now, beginning with the petitioner.
Hey, it's probably appropriate to move for admission of exhibits this time. There's an easy way and a hard way, and I'll do it the hard way, unfortunately. Exhibits A through B, supplemental exhibit F filed yesterday, G through M, corrected exhibit N was filed in February, and then exhibits O through U. I'd like to remind everyone, full notice was provided to all parties relevant. Everyone who reached out and had concerns or questions has been dealt with and addressed. Those parties who have not responded in any meaningful way are subject to ruling here today. I'd also like to remind everyone that statutory and regulatory requirements have been satisfied and the requested relief is fair, reasonable, and in keeping with the past practices of the board and this hearing examiner. And I'd ask simply the hearing examiner approve the request as pleaded, and thank all here for their time and attention to this matter. On that, let's submit.
Good.
No objections to the admission of the exhibits, and again, no objection to grading.
Okay, could we take a brief recess of my council? Brittany? 2 minutes. Hey, can you go back on the record? Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that Ovindiv has provided sufficient notice of opportunity to non-consenting owners and to those owners who identified in the RAA and did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified, given the economic and geological conditions present with these wells. I find that it would be appropriate to impose the requested non-consent penalty. I find that Ovindiv has met its burden of proof to show that they are entitled to force pulling of the named interests and other reliefs requested in the request for agency action. Mr. Mayo, would you prepare a proposed order?
I'm happy to. Hopefully by the end of the week, I'll get both of those.
I then will present those findings and conclusions to the board next week at the board hearing. Any other comments before we close? Thank you for your participation, and we will adjourn this proceeding.
Thank you.
Thank you.
Thank you. Okay, just a couple minutes. Okay.
That part.
Good morning, everyone, and welcome. My name is John Rogers. I'm environmental manager with the Utah Division of Oil, Gas, and Mining, and have been appointed by the Board of Oil, Gas, and Mining as a hearing examiner for this proceeding. Today is Wednesday, March 20th, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-018, number 132-35. In the matter of the request for agency action of Ovintiv USA Incorporated for order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the three Jorgensen wells identified herein, in the drilling unit established for the production of oil, gas, and associated hydrocarbons for the Lower Green River Wasatch Formation, comprised of all sections 4 and 9, Township 3 South, Range 2 West, Winnet Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We'll also be hearing testimony and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division staff, legal counsel, petitioners, and department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public present that wish to comment on these proceedings? Seeing none, let record show no public respondents are present. We'll take appearance in council this time.
Ginger Utley of Lear and Lear PLLC on behalf of petitioner Ovintiv USA.
Gary White, Assistant Attorney General for the Division of Oil, Gas, and Mining.
My counsel is Ms. Emily McKay of the Attorney General's office. Some procedural items first. I received declarations from Mr. Jordan Lair, a senior land negotiator for Ovintiv, and Mr. Christopher Wall, a senior reservoir engineer for Ovintiv in this matter, and I reviewed them before this hearing. Does the division have any objections to these declarations, or at least individuals being declared as expert witnesses in these matters?
No objection.
They are recognized as experts in their particular fields in this matter. That way, our witness present today,
They are.
we now swear them in.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
All right, we'll now proceed to Utley for your presentation.
Thank you. Pursuant to the order designating the hearing examiner in this cause entered on February 16th, in uncontested matters such as this, where no new novel issues are presented, testimony may be submitted by a declaration, so long as the witnesses make themselves available for questions posed by the hearing examiner or division. Accordingly, as we've just talked about, Mr. Lair and Wall are present virtually for that purpose. Both have submitted declarations, and we can confirm that this matter is uncontested and presents no novel issues. The board, and by designation the hearing examiner, has jurisdiction over this matter pursuant to Utah Code annotated 40-6-6.5 and implementing regulations. A copy of the request was mailed certified mail to the known parties sought to be pooled and mailed regular mail to all other production interest owners in the drilling unit at their last addresses disclosed by the relevant realty records of Ovintiv's internal records and to all relevant federal and tribal agencies. Additionally, notice of the filing of the request and this hearing was duly published in the Uinta Basin Standard on February 28th, Deseret News on March 1st, and the Salt Lake Tribune on March 3rd. On March 11th, the division filed a response expressing no opposition to granting the request. No other objections or responses to the request were timely filed. And just to briefly summarize, this cause involves the compulsory pooling of the drilling unit established for the Lower Green River Wasatch formations, comprised of the entirety of sections 4 and 9, Township 3 South, 2 West, Range 2 West in Duchesne County. This drilling unit was established by board order entered on July 21st, 2015, cause 139-34, as supplemented by its order entered on June 21st, 2016, cause 139-137. Ovintiv is the majority interest owner as shown on Exhibit E and as stated in paragraph 9 of Mr. Lair's declaration. Pursuant to the 139-134 order, which is on file as Exhibit B, Ovintiv spelled the Jorgensen UT 16-9 3-2-9-4-1HR on January 10th, 2023 with a first date of production of April 28th, 2023. It spud the Jorgensen UT 16-9, 3-2-9-4-12H on December 15th, 2022, with a first date of production April 28th, 2023. And it spud the Jorgensen UT 16-9, 3-2-9-4-42H on December 12th, 2022, with a first date of production of April 28th. And I need to make one correction here. The spud dates I just read are correct. However, in the request for agency action, we inadvertently used the wrong spud dates. The new spud dates, or this corrected spud dates, is noted in paragraphs 7 and 23 of Mr. Laird's declaration, where he explains that. And he explains that the change has no impact on the acreage weighted landowner royalty, as the leases weren't taken during the relevant time period.
Do we need to get that corrected with the new exhibits, or is that?
It's corrected in Mr. Laird's declaration, and it will be correct in the order.
Okay.
The subject wells are identified on Exhibit D. As set forth in paragraphs 2 through 7 of the request, as of August 1st, 2015, the sole vertical well producing from the subject lands converted to a 1280 allocation. Thereafter, Ovintiv began operating 3 long lateral horizontal wells producing from the drilling unit, all of which were subject to pooling orders. In the 139-134 order, Ovintiv agreed to waive any further recoupment owing under the pooling orders and agreed to modify those orders, which it did. In response, the board entered the 139-137 order and confirmed that the existing wells are all payable on a 1288 basis. Therefore, waiver of recoupment as provided in the 139-134 order is not applicable. And I would also like to make you aware of a couple of other changes since we filed the request. First, Dawn Irene Sojer. She's identified in the request and in paragraph 13 of Mr. Laird's declaration as a party to be pooled, but Ms. Sojer has executed a lease with Ovintiv, and therefore we are removing her. Second, the estate of Flora Scott is also identified in the request and in paragraph 17 of Mr. Laird's declaration as an estate to be compulsory pooled. Her estate should also be removed because the mineral interests of the estate have been leased.
What was that one again? I'm sorry.
Flora Scott.
Just one question there. So she was listed as a deceased. So did they probate to see who owned that, or how was that handled?
What happened is the estate's minerals passed to David and Sandra Sant by a quitclaim deed. Dan died, and Sandra recorded an affidavit terminating all of his interests and leaving all the interests conveyed by the quitclaim to her. So she had them, and the quitclaim had the catch-all clause that conveyed all of the minerals, but it wasn't indexed against the land, so the title examiner missed it, and it wasn't in the title opinion. Okay, with the removal of Dawn Sojer, there are 18 parties to be pooled and declared as non-consenting in the subject wells, as identified in the request and in paragraph 13 of Mr. Laird's declaration. As reflected in Exhibit E, the aggregate gross working interest of these parties in the drilling unit is 0.30%. As outlined in Exhibits F through T, the requisite notices of opportunity to participate in the subject wells were provided to these parties, including by publication to Peggy Handley, Shirley Marie Cope, who's now known as Shirley Marie Rasmussen, Daniel Smith, and Wesley Claysmith, as authorized by the board's order entered on February 16th, 2024, but not responded. In addition, although Ovintiv believes it has leased all such successors and voluntarily pooled their interests pursuant to the pooling clauses in said leases, there may be additional parties claiming by, through, or under certain decedents as identified in paragraph 17 of Mr. Laird's declaration, whose estates have not been probated or are incomplete in the distribution of the subject mineral interests. Pursuant to the board's order entered on February 16th, 2024, the requisite notice of opportunity to participate was provided to them by publication and no responses were received. Exhibit W admitted in this cause is a true and correct copy of the affidavit of publication of the notice of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit Y and paragraph 23 of Mr. Blair's declaration, the average weighted fee landowner's royalty in the subject wells is 18.143443. As outlined in paragraph 24 of Mr. Blair's declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the drilling unit. Their names and addresses were derived from a 2022 title opinion as supplemented by a record search by Ovintiv's contract landmen and Ovintiv's internal records. Exhibit CC reflects the status of the certified mailings of the request to the expressly named control parties. As the record will reflect, none of the parties identified in the request as being pooled and declared as non-consenting owner in this cause timely filed a response or made an appearance today. Consequently, pursuant to Utah Administrative Code R641-104-150 and R641-108-400, Ovintiv moves to enter an order of default against them. Is that correct? Okay. As outlined in paragraph 7 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the subject wells is $75,000. Exhibit BB and paragraph 9 of Mr. Wall's declaration outline the risks assumed at the time of the spud of the subject well. And with that, I am ready to turn to my witnesses, Mr. Lair. Will you please state your name and business address for the record?
Sure. My name's Jordan Lair, and the business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your position with Ovintiv?
I'm the senior land negotiator with responsibility over this drilling unit, among others.
Okay. And would you provide the corporate and bonding status of Ovintiv?
Sure. Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Ovintiv Production Incorporated.
Thank you. Were exhibits C through V and X and Y prepared by you or Ovintiv personnel with your input and review?
Yes, they were.
And have you read and can you confirm that the statements in your declaration are true and correct?
Yes, they are.
Did you authorize your counsel to sign on your behalf?
Yes, I did.
Are there any changes or modifications you'd like to make to the declaration before we move on?
Just the ones that you outlined, insofar as the change to Dawn Irene Soger, as far as her having leased to us subsequent to the issuance of that declaration, and then also removal of Flora Scott, who again got in contact with us, or her successors rather, to inform us of the indexing of that quitclaim that you had kind of gone through, which again was after the date of the declaration.
Okay. As you are an expert in general petroleum land management, and in your expert opinion, are the terms and conditions of the JOA submitted as Exhibit X fair, reasonable, and consistent with those commonly accepted by industry, and in particular in the Uinta Basin Standard with respect to horizontal well operations?
Yes, they are.
Thank you. And with that, I will open for questions from the division.
Mr. Lair, I'm glad you clarified that it wasn't Miss Flora Scott that reached out to you, because that would have opened up a lot of questions.
We don't engage in that kind of consulting, let's say.
No necromancy or anything? Okay.
Yeah, we don't use those folks.
Very good. Let's go to paragraph 7 of your declaration. You state here, you provide the actual spud dates. Is what you refer to in footnote 2, the spudder rig, is that the dry spud date?
That's correct. So those dates will align with the dry spud date that's on file with UDOGM. And they will correlate to the day that conductor is actually set for each of those individual wells.
Great. And I'm still at footnote 2. You stated that changing or correcting the dates didn't have any impact on the average weighted landowner's royalty. Is that because there were no leases taken between the dry and the wet spud dates?
That's correct. There were no leases taken until after the later of those two dates, as to anything new in the drilling unit.
Great. At paragraph 23, you talk about calculating the average weighted fee landowner's royalty as of the date of spud. But I know we have 3 different dates, so can you clarify which date of those 3 outlined in paragraph 7 was the date used for the calculation?
We use the earliest of them, but in this instance, so that would have been.
Is that December 12th, 2022?
That's correct. But in this instance, again, it wouldn't have impacted the calculation in any way because there weren't any new leases to incorporate. So effectively, the average weighted royalty, regardless of which spud date we're looking at, would be the same number.
Okay, and to put it differently, no leases taken between December 12th, 22 and January 10th, 23.
That's correct.
Okay. That's all the questions I have, sir. Thank you.
No. Mr. White, you bring up an interesting question, and I think we had this in our last issue, is which spud date are we going to use? And I think we need to get on board practitioners, the division, industry, of what we're going to do so we're consistent there. Would that be something that everyone would be willing to look into?
Yes,
Yeah.
absolutely.
Do you think that's a problem? I mean, because we're talking spud date, I think it can be a different thing with different people. So anyway, we'll proceed in that. It's a matter we won't concern ourselves with, but something I think we need to look at. Any more questions or?
No more questions for this witness.
Okay.
All right, so then, Jordan, we're all done with you, but if you could stick around for a minute. Chris, will you please state your name and business address for the record?
Yes, Christopher Wall, 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with Oventive?
I am a senior reservoir engineer with jurisdiction over this unit and others in the Uinta Basin.
For exhibits B, AA, and BB prepared by you or Oventive personnel with your review and input?
Yes,
And have you read and can you confirm that all the statements made in your declaration are true and correct?
yes,
Did you authorize your counsel to sign on your behalf?
yes,
And are there any changes or modifications you'd like to make to your declaration?
no,
Thank you. In your expert opinion, are the actual costs of the subject wells as reflected in Exhibit Z fair, reasonable, and necessarily incurred?
yes.
Is there anything you would like to add about risk?
No, not at this time.
Okay. Then I would again open Mr. Wall up for questions.
Mr. Wall, you already know what I'm going to ask you. And it's, you again beat the estimates from the AFEs in all 3 of these wells. So can you help us understand how you did that?
Yes, so again here, we were able to come in under the AFE mostly on the completion side. partially due to a design change, but also due to a contract. So we were able to secure a completion fleet under contract, which helped us reduce our costs.
Okay. If you look at Exhibit BB, I believe the purpose of this exhibit is to outline the pre-spud risks and then state what the actual occurred risks were.
Mhm.
It state, and I don't know if you prepared this, but it states here that there were some drilling and operational challenges. There was a fishing job required to recover a broken motor, which ultimately ended in redrilling the surface hole on one well. Can you help us understand what happened there?
Yeah, so the 1HR, the reason why it has an R is because it's a redrill. And what happened was, I don't know exactly what happened to this motor, but it basically failed. And when it failed, it broke in half. It seems to be a flaw in the manufacture of the tool. So it's a tool failure, nothing that Ovintiv was doing operationally that caused the failure. However, what it did do was cause us to incur fishing expenses. So we tried to get as much of the tool out of the hole. But ultimately, the damage that was caused by that failure necessitated us to actually just start over on the well, which cost us time, but and also money.
Okay. Anything else? All right, that's it. Thank you so much.
I got a question. Our first two matters today, we force pulled one well. Here we're doing three. What's the strategy of when or how many you do at one time? We'll start pulling. I mean, that's an answer to the landman or.
It might be more questions.
Yeah, that's more of a land issue, I think.
I mean, speaking to it broadly, in this instance, we drilled 3 wells at the same time, so to speak, one right after the other, versus in the prior 2 matters, those were single well developments. And so in most instances, we're going to seek to compulsory pool all of the wells at the same time that are available. In this one, as Ms. Utley had already mentioned, the existing 2-mile wells are subject to a prior pooling order. So the 3 that were currently not subject to a pooling order are what is being presented here. So I think to answer the question more broadly outside of the matters today, we're going to seek to try to compulsory pool all wells that we have the ability to at one time, where that's something we can do. And in the instance where it's the initial well in a drilling unit, you know, we're going forward with that one and would seek probably future compulsory poolings as may be necessary for new wells.
So, for example, in one drilling unit, you have one horizontal well at a time. You'd have to come in and force pull that a new well in there, or 2 or 3 if you decide to do that. So this matter would not affect any new wells. Is that correct?
I believe, to my understanding, and Ms. Utley can chime in or add to it, what we are accomplishing when we are entering these forced pooling orders is we are allowing for a JOA to be put in place with those parties such that we can propose subsequent wells to them. And I do think, while I've not been part of this yet, on subsequent wells, there may be a shortened version of this that we're able to accomplish, whereby we kind of submit proof that we propose these wells to these parties and ask that the same risk penalty be assessed, et cetera. So my understanding is that in entering these orders now for these single well developments, we are going to gain some efficiencies on subsequent wells, and we'll have a JOA in place with those parties that they would be, governed by on subsequent wells. So that's, again, my understanding and sort of a reason that we're seeking to do this on the single well developments.
So, Ms. Utley, what would happen if down the road one of these deceased parties has probate, they get it all taken care of, there's other parties that say, I'd like to participate in this new well. Do they have that opportunity?
A deceased party.
Well, the other deceased parties, and they didn't have any probate. But what if
Okay.
in the meantime, between now and whenever that well's drilled, they probate that and they know who everyone is, and some of those people want to participate.
I'm not entirely sure.
And
Yeah,
I'd
can
be
I
glad to
ask
hear
the
from you. I
minister
just
to help
want
me
to
out
clarify.
here?
No, I think the question, maybe it's phrased in a way that's a little confusing, but I think I understand what you're getting at, and that's Utah elections are on a well by well basis. So when that subsequent well is drilled, those parties will be given, if they're now conclusively determined to be owners, they'll be given an opportunity to participate.
Okay,
just
so
as
they'll
they
have that
would.
opportunity.
That's right.
If between now and whenever those new wells are drilled, ownership changes or more clarified.
That's right. And if there isn't any changes, my understanding,
Yeah.
as Mr. Lair mentioned, is that the statutory change a few years ago allows motion to modify and refile so that this order here today can be applied to subsequent wells, but each of those owners have
But
to have a new.
the longer
motion.
time between wells is going to allow for more change in ownership. That's done.
I mean, even in the 30, 40 days that an REA is pending. there's
Okay,
changes.
just want to clarify. Okay, thank you.
Yeah, and I mean, the only thing I would add to that is, if we are informed of probate being filed on one of the decedents named here and it's recorded, obviously then the subsequent elections would be made to those heirs that are determined by that court order. So I think what we've established is those parties would definitely have the ability to participate in future wells, subject to the JOA that's being put in place here.
Okay, thank you.
One question, since, just to make sure we have a full record, and since we're looking at multiple wells here, the board has indicated a desire to review the risks associated with each individual well. Could we go ahead and confirm that the risks discussed in Exhibit BB represent each individual well? And are there any distinctions between each well?
Mr. Wall, would you like to address that?
Yes, so the pre-spud risk, the drilling and operation challenges, all of those apply to every single well. Obviously, as we discussed a little bit earlier, the 1HR had a specific risk that did incur or suffered a risk. So that actual occurred risk only applies to the 1HR, the Jorgensen 1HR.
Okay, thank you. And I just wanted to make sure we confirm that's for each one.
And that does bring up one more question from me. In your expert opinion, do the risks shown and outlined on Exhibit BB justify the imposition of a 300% risk compensation award?
Yes.
Thank you.
Have you had your chance to talk to him? Yeah.
Yes, I have.
Okay, I thought we did. I want to make sure we can pass that. Okay, you have no more witnesses at this time?
No more witnesses.
Concludes your presentation.
Thank you.
Okay.
I'd like to move for admission of exhibits A through EE. And just reiterate that all statutory and regulatory requirements have been satisfied. The requested relief is fair, reasonable, and justified, and therefore we ask the request be approved. We would also like to reiterate that this matter was uncontested and presented no novel issues. And I would just like to thank you, Mr. Rogers, for your time and effort here today and everyone involved, and for making these virtual appearances so easy and possible for us to do this. So thank you.
I am a little confused here. Have we had exhibits? Okay, I know we.
Oh,
Can we go ahead and exhibit those?
sure. Yes, the admission of exhibits A through EE.
Mr. White, divisions have any concluding statements?
We don't have any objection to the admission of the exhibits, and based on the information presented, the declarations and the exhibits, the division does not have any opposition to the granting the request for agency action.
Thank you. All right, having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find Ovintiv has provided sufficient notice of opportunity to the non-consenting owners, excuse me, that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that the Ovintiv has met its burden of proof to show that they have entitled to enforce pooling of the named interest and other reliefs requested in the request for agency action. Ms. Utley, will you prepare order?
Yes, I will.
Thank you. I will then present our findings and conclusions to the board next week at the board hearing. Any other comments before we close? Thank you for your participation, and we'll adjourn this proceeding. Thank you to those participating online.